attorney with, okay. That's okay. She's with Armstrong and Armstrong Grove and Wawrzynek, is that right?
We're close, Wawrzynek.
Okay. In Mattoon, and she's done numerous programs for us over the years. So Janet, I'll just let you take over from here.
Okay, thank you. And I am open to questions as we go through this. If you want to use the chat, Shannon's going to kind of monitor that for me because I can't read and talk at the same time. But I want to tell you a little bit about me because it's a little different. I have been in practice 36 years in this area geographically, and I've always focused on estate planning, disability, trusts, wills, probate, guardianships, and on the side we end up doing a lot of real estate work. But when I left after 1 year of practice with Craig and Craig here in Mattoon and went to a bank as a trust officer for 10 years, and I had a judge say, "What are you going to do there?" And I said, "I really don't know. They just want an attorney." So he said, "I'll tell you what you're going to do. You're going to learn a whole lot of new ways to say no." And he was spot on, because that's why people hire banks as trustees, is because they know the banks will say no. But what has really happened is I've had a fantastic education through my clients and their families and their experiences. And I've always really enjoyed passing along some of the finer details, the tidbits, because I think that advanced planning for your life, your disability, and your death is priceless gift that you give your family and those around you. But as a side note, it really helps you. And one of the things that is the most difficult to deal with, we have people who are mentally ill, and then we have people who have some form of memory deficit dementia. And I will tell you, in my own family, during COVID, it was extraordinarily difficult because my dad went downhill so fast being in isolation in a facility. And my mom called me up one day because they were in an assisted living apartment together. And she goes, "Well, I'm either going to be arrested for murder or you're going to have to find Dad a spot in a memory care unit." So I feel your pain, but I was able to help my family in many ways, both my siblings and my mom and my dad, because of people like you and my clients that have had me help them and learn with them how to deal with this situation. So please, if you do not want to open up about your specific situation and you have questions, this is an opportunity to talk to a lawyer at no charge. As I tell Shannon and her people every time, I will talk to any of you for half an hour if you call me at the office sometime. And it can be after hours or weekends. I don't care. I just really think a little bit of what I know can help people manage a difficult situation. So take advantage of me. You know, my husband's like, "I have to be nice when they call." I said, "Yes, you have to be nice when people call." Any questions so far? I don't see anything. In the handout, which you may or may not look at as we go along, I'm going to focus on a couple of what I get in the way of the most common concerns of my clients. And I want to ask you a question. You know, you're here for a reason. I'm not sure what your goals are. If you have parents that you're caring for, because everybody I can see looks younger than me, or do you have early onset dementia closer to home? I sometimes think my husband's worried about that with me, but the big thing is what matters most to you right now. And for some people, it's death and dying in the probate process. For others, they're worried about income taxes and estate taxes. It could be maintaining your privacy or not losing control of your assets or everyday decisions. But what I'm going to focus on more than you probably want is preservation. I'm talking about preservation of your sanity and preservation of your assets, so that if a spouse or you have to go in long-term care, you can understand a little bit of the framework for how people pay for that in our society under the present rules and regulations. Underline present. They are always talking about changing the rules because there are so many more people in the baby boomer age that are getting older and need long-term care costs. And they're still trying to figure out the government level, how are we going to pay for this? So I have a prediction. I predict that just like they have the foster care system for children, as the next 10 or 20 years, they're going to have a foster care system for grandparents, and you get to adopt me. If I am healthy, like my dad was, he really didn't have any medical problems. He just needed help day-to-day living. And he would have been fine in a very kind place, where someone younger than my mother was able to care for him and guide him and put up with him telling you the same thing 40,000 times a minute. So as part of that process of deciding what's important to you, and let's again focus on asset preservation and sanity preservation, is, think about who's on your team, who has information and expertise that might help you. And believe it or not, a lot of people get a lot of help from an investment advisor, whether it's a broker or a family member that you trust, but it's also can be an accountant, someone who deals with taxes. It can be, of course, an attorney. Insurance people sometimes are very well versed in long-term care costs and how to finance it. You need to make friends with a funeral director at some point in your life, because I claim that if you will plan your own funeral as much as you can tolerate, that's doing your family a big service. And then there are trust officers and banks. And when I worked at First Mid, people would come into me and they weren't going to use our services, but they just wanted some information so I could help them understand what I'm doing with you this evening. And then, you got seminars like this, so you're already tapping into some resources, but figure out it takes a team, it takes a village to raise a child, and it takes a village to help people that have special needs of any kind as they age. Best advice I can give you, and I've got this listed twice in the outline at the very end, is, I call it family planning. Have an idea of what is going to work for your family. And I got to tell you, a lot of attorneys have clients that call for an appointment because they want to do estate planning. So they do a will and they plan for who's going to get their stuff at death and who's going to be in charge of getting it done. I have found that planning for disability is actually more important than planning for death, because if I become disabled and I've done no planning for that, the only way my husband is going to be able to manage my IRA, sell the house, take care of anything else it's in my name alone. But even though his name is on the house, and even though he's beneficiary of my IRA, which happens to be our biggest asset, I think that maybe is why he's hanging around. He can't deal with that if I become disabled. And it's very frustrating to spouses because they think that, well, I'm, a spouse, I'm beneficiary. As long as she's alive, it's her account, not yours. And when you sell real estate, it doesn't matter if it's joint with right of survivorship or how your names appear on your deed. You cannot sign my name to that deed unless I give you that power. But my husband, signed, of course, wonderful estate planning documents shortly after we were married. And fast forward about 10 years, his car broke down and he's a real tightwad. So I had told him, we need to plan for how you're going to, replacing your car. I don't like to get stranded someplace and then have to hurry and buy a car. So we went and picked one out. And he said, let's just wait 90 days. A nice new Buick, our first new car. And I said, okay, 90 days. Well, guess what happened? He's working in Champaign. His truck breaks down. We have to have it towed home. And this is in the middle of the week. And he says, what are we going to do? And I said, I'll just go to Casey Summers and I'll buy that Buick. And he's like, okay. So I got in a cab. Then he took my car. That was our plan. He got the old car. I was going to go get the new one. So I took a cab to Casey Summers and bought the car. He comes home and he's upset. He goes, what did you do? I said, I told you I was going to buy the car. He says, well, I didn't think you'd really do that. And I said, well, I did. He goes, well, I don't understand. I said, well, don't worry. The car is in your name and my name, and your name's on the loan too. And he's like, how did you do that? And I said, well, back in 1997, you signed a power of attorney for financial matters, and I have complete control over signing your name to anything. So he learned. And now when I go to seminars, I used to have a 6-day seminar in Florida every year. And he'd say, now, can I sell the house while you're gone? I said, yep. So he learned. And that's important that you understand that a power of attorney for financial matters, there is no substitute for that. There is a separate power of attorney for healthcare. And a lot of people have those because the hospitals and other, like the senior centers, they will help provide you with the form and help you fill it out. And that's great. But if you don't have a healthcare power of attorney, there is a law called the Surrogate Decision Maker Act, which allows your next of kin, being a spouse or if none, then your children, to make your healthcare decisions when you can't make them for yourself. So you've got a backup plan in the statute. But if you don't have a power of attorney for financial matters, there's no backup other than hire an attorney, go to court, have a guardian appointed, and have the judge approve selling the house or making expenditures. It's very expensive. And when we used to do these programs live, Shannon, do you remember what I used to tell people? Make sure when you leave here, you go look at my car with the giant sunroof and the leather seats, all paid for by people that did not have a power of attorney for property. And I had to go to the hospitals and nursing homes and have hopefully semi-competent people sign those documents to avoid going to guardianship court. And a lot of times it didn't work. After grandmother's had a stroke and is unconscious, it's too late to sign. And a lot of people misunderstand that. The other common misunderstanding is because people know they have a power of attorney from the hospital and it covers healthcare. When I was at the bank, I can't tell you how many times they would come and get me and say, could you come talk to so-and-so? And he'd say, well, grandmother had a stroke and I need to be able to sign her bills. And I said, okay, give us, and he goes, I've got power of attorney. And of course he hands me the power of attorney for healthcare. Doesn't work. So be very, very careful. The other problem I see is that when people do prepare powers of attorney, where there's healthcare property, sometimes they just put one person's name in there. They don't have successors. This is especially dangerous for spouses because you need to make sure that if you trust your spouse and that's who you're going to name, go ahead and name your spouse, but make sure that you have at least 1 or 2, if not 3 or 7 backup people. If you've got 7 kids, pick the ones that are going to do the best job for you. And please don't worry about hurting their feelings. It's not about them in this case. It's about who's best for your agent, whether it's healthcare or financial. And you might pick, like my parents did, my sister's in the medical world. So she's first on their power of attorney for healthcare. For some reason, they think I can handle money, or maybe it's because they didn't like me that they made me agent under their power of attorney for financial matters. Because my sister definitely has the harder job, definitely. So any questions on those so far? I don't see any.
So I have a question. So
Yes.
you're saying that when you have a power of attorney, that is effective immediately?
You have to sign the document so that it is either effective immediately or effective when you sign another document activating it, or a physician familiar with your condition certifies. When you sign the document, you have to choose what method. I basically tell all my clients, I am drafting this so that's effective immediately. And they sometimes are afraid because they're like, well, I don't want to give my daughter or grandson that power now. And I'll say, why not? Don't you trust them? If you don't trust them now, why would you trust them when you're disabled and need help? And if you make it effective immediately, just like buying the car, it was a really slick tool when we needed it. I don't care what my husband thinks about it. I thought it was great. The other thing I'll warn you about is my husband got injured on the job and we ended up at the ER 2 days in a row because the pain pills weren't working the first trip, had to go back. And on my 3rd day of picking up his narcotic pain control, I had to provide a power of attorney for healthcare, even though I was his spouse. At the same time, when I was calling around for a second opinion from a specialist, he stepped on a nail and it got to be pretty bad. I was told that if I did not have power of attorney for healthcare for my husband, I would not be able to make him an appointment with a doctor he has never seen. I was able to make appointments with his regular physician, but I could not make appointments with new doctors. I was shocked, and I do this for a living, but I'm warning you to be cautious with that because the second thing is keep them handy. At our office, when people sign powers of attorney or any other document, we immediately scan them. And I tell them, you can call me 24/7. I'm in the phone book. I can run to my computer at home in my bunny slippers and email that anywhere you are. I've had clients that needed it out in Salt Lake City on vacation. I've had clients that were in Florida, or, whatever else. We can get it where it needs to be instantly that way. And you can do the same thing. In my own case, I keep a copy of my parents on my home computer. And I keep emailing them to my sister because she doesn't know how to store stuff so she can find it again like I do. So it works. But
I know.
yes, good question.
Yeah, some of our meetings, Janet, some people suggested keeping a copy in your phone and then
Yes,
also in your glove compartment of your car.
absolutely. And I will tell you, there is a definite split in this our society where I'm old enough that I would say I recommend, especially for people that travel to Florida or Texas, wherever, just go ahead and put a copy at least to the healthcare, in your glove box. And I've had young clients go, what's a glove box? That's how you know you're old. Now, was there another question anybody had? Okay. So be aware, make sure you have both powers of attorney and that you have successors on there. And I highly recommend you make them effective upon signing. The healthcare doesn't ask you that question, but the power of attorney for property actually has a place that you can fill in that you want it effective immediately. And also be aware that they're always tinkering with the powers of attorney. It's like the tax laws. They made a change in the power of attorney for healthcare, and it was effective in the middle of August this year. And of course, we didn't know that for a couple of weeks. It's okay. And just because you have powers of attorney that may be 5 or 10 or 20 years old, they still work. They're still good. But plan for disability. And remember, sometimes when I'm working with clients, part of what I do is I try to get them to acknowledge that they might be like my dad, where he was perfectly healthy, but was not mentally hanging on to the real world. And so you have to plan for your own mental disability. And in fact, dementia runs in my family. And I mean, he was 93, so, it wasn't like early onset, but I have clients where sometimes we draft their powers of attorney, and in fact, to protect them from themselves, because so many times if they start dementia and they're still high functioning, they'll have caregivers or somebody that try to get them to change things, whether it's their estate plan, who gets their stuff, or who's in control. Or sometimes they get inappropriately mad, like my mom gets mad at my sister all the time. That also runs in the family. And blames her for stuff or things disappearing that, that's not why she can't find them. It's because she's 93 and she can't see very well and she's not going to bend over. But so as you plan for needing the powers of attorney, just remember you need to protect yourself. And this change that was made in August is a new check the box on a power of attorney for healthcare that says, if at any time I sign a document to revoke or take any action to revoke this power of attorney for healthcare, I want there to be a 30-day delay in its effective date. And that's to get over some of these undue influence situations where, maybe the agent's doing a good job, but the sister or the cleaning lady doesn't think so. So protect us from ourselves. And of course, what most people think of with estate planning then is having a plan for who's going to be in charge and who's going to get your stuff when you die. And in fact, first half of my career, my friends never, ever wanted me to talk about my job because death and dying is not something that they wanted to talk about. And now that we're all over 60 and most of us are on Medicare, they're like, okay, why don't you guys go for supper tonight? And then they'll get me in a corner. And my husband's like, call her and make an appointment so she can bill you. But it is important to plan for disability and plan for death. And there is some information that I am surprised clients don't know. I have a lot of clients that cannot tell me what their assets are. And I don't care if they're 40 years old or 50 years old or 60. I've had retired professors in the School of Business at U of I and Eastern who can't tell me what their income sources are. They don't understand their pensions. They don't know the different kinds of retirement plans they have. They really don't know. I have a lot of people that own MetLife stock and don't know it, even though they're getting dividends annually. They're getting cash dividends annually, and they have to report that on their income tax returns, but they still don't understand that they own stock. So many, many times when someone has passed away, we didn't know they owned it, and we've had to reopen the probate process in the court in order to sell their MetLife stock. I'm telling you this because I'd say half of all the estates we have, we always ask, do you own any MetLife insurance? Have you ever owned any MetLife insurance? Because back in 1998, I believe they switched from a mutual company to a stock company. And so if you had a policy, they automatically gave you some stock, but you didn't get a certificate. It was all electronic. And so people just don't know they own it. But we've had people that own, several $1,000s worth of MetLife stock and did not know it. So if you have an idea of what all you own, and if you're dealing with your parents, it may take a while, but you might be able to piece together what all they have. And remember that January and February, anyone who has paid them interest or dividends has to send them a 1099. And that's a great way to track back into what they own. But here's the other thing. If the bank paid me less than $10 in interest, they don't have to give me a 1099. So you have to watch out for the little stuff. And also the other thing, we tell people, check at least once a year for your name on the unclaimed property list with the Illinois Secretary of State or Treasurer. It's great. It's very easy to use. You type in your name and you follow their process to claim any unclaimed money. And it's frustrating for me because I know I helped my parents sell their home and they had lived in that for 55 years. And like 2 years later, the power company, somebody let me know that the power company had paid the money over to the state of Illinois. Now that's, or the state of Indiana, as uncollected property. They had our address, they had our forwarding address, and yet they couldn't do it. So beware, you'd be surprised. I regularly put in my in-laws' names, even people who've passed away. And when we handle estates, we always go and check and see if there's any unclaimed property they don't know about. So fun things to do in your to-do list, right? And you all have time for all of this.
One thing I usually recommend when we do this program is get a notebook and put in your life insurance, your IRAs, any stocks. Make a list of what they are, and also put your passwords in for all your accounts on your computer. And then put your wills, put your power of attorney, copies of all these, copies of power of attorney, copies of will, everything in there. And I give one to each of your kids.
Yeah. And my father got tired of paying safe deposit box fees, so he bought a safe. And I said, well, where are you going to keep the key? And he goes, oh, I didn't get a key. I got a combination. I'm like, oh my gosh, we're never going to remember where we put that. He says, don't worry. I got it someplace where I know you'll find it. In fact, he had a piece of masking tape inside the liquor cabinet door. And what was funny is when they sold their home and downsized, we had a ceremonial moving of the masking tape so that the combination was still, because I don't care what size condo they bought, it had a liquor cabinet. And yeah, we knew he was slipping when we found a big red wine stain right in front of the liquor cabinet when they moved. But yeah, whatever works for you. But you have all kinds of forms you can get online. In fact, when people come to us for planning, I send them a form to help fill them out. If you guys would like to see one of those, if you'll email me or let me know, I'll be glad to get that, or I can get it to Shannon too, to share with you. It's just because kind of it spurs your memory. And don't forget MetLife stock. Don't let the attorneys get that much more fee income because MetLife didn't remind you owned that. The next rest of my presentation, I'm going to focus on Medicare and Medicaid. Does that worry people to some degree? I think if you're here because of Alzheimer's has touched your life somehow, it's a big concern. And like I said, I've learned a lot through my clients, and now we're going through it with my mom. And the big thing is I know what advisors I need, because I know the surface, but the details are so specific and each family is so different that it's really important just tonight to kind of get the ideas. And please remember that they are always talking about changing the rules for getting public assistance to help with long-term care costs. Number one, Medicare, Medicaid, they both pay for long-term care costs in certain situations. Medicare pays, I believe, for less than 3% of all long-term care costs in the United States. They don't pay very long and they don't pay very much. I don't know if you're aware, but Medicare starts out paying a large amount when you are in skilled nursing, and then it whittles back so that it's less and less the longer you're there. And if you no longer need skilled care, Medicare doesn't pay if you're there for custodial care. That's kind of the two terms I was taught. And Medicare doesn't necessarily, I think they cut it off after 100 days still. That's been a rule for a long time. And so just be aware. Medicaid, here's something I've added to the outline. I've had a lot of clients who have VA benefits from themselves or a spouse being a veteran, and a disabled child sometimes qualifies for VA benefits as well. And what I found out through a client of mine is that the VA doesn't reach out to you. You have to reach out for them and ask, are there any home care benefits available to me or my spouse? Because sometimes they'll even pay for a spouse who wasn't the veteran. Can we get some assisted living care? Can we get nursing home care or some financial assistance? So be aware that's a really good tool. And I just happened to be involved with some clients, a lady I worked with at the bank, so I knew her really well. And as her husband was going downhill, he was a veteran. And when my client that was the VA benefit consultant was in, he said, have him call me. And he got them like $1,700 a month to help with home care. So the gentleman was able to stay at home much longer because they had that extra financial assistance. You may or may not be aware that sometimes staying at home is the expensive option. And when you truly run out of cash, a nursing facilities where they end up. So the options, you have many more options now than you did when I first started. So be sure that you get your advisors around you and you talk to people. I know I'm involved at the Lifespan Center in Mattoon, where they have some people that are federally funded to help find benefits, and they tend to focus more on Medicare and Medicare enrollment. I'm trying to get them to get people in there that understand public aid a little bit better to help us with that. Two big myths. I hear this all the time. And I'd say at least twice a week, I have new clients come in and all they want to talk about is Medicaid. In many cases, it's too late to do any planning for it, but at least they'll understand it. Two big myths. Public aid never takes anybody's home. That's a myth. They never do. They never have. The most they will do is put a lien on it. And one of the problems people don't understand is that if you're single, not married, and talk about me, if I'm in a nursing home, my husband's already gone, and I want to keep my house because I want to move back there. But the problem is, if I run out of my own money and I'm on public aid, I have $30 a month spending money. And the rest of it goes to pay my care. And then whatever the shortfall is, the state of Illinois pays through public aid. So $30 isn't going to be enough to pay my real estate taxes or insurance or mowing or any repairs that have to be done. So the fact is that you may be in a position where you're forced to sell your house because you can't afford it, but they never take your house. Now, if in fact your doctor can certify that you are expected to return home within 6 months after being in the nursing home or whatever skilled care you're receiving, then public aid will allow you to keep extra money so you can keep your home. But but that lasts for at most 6 months. And it may end earlier if it's determined that you're never going to move back home. So be aware, they never take your house. They will put a lien on it. You will not get kicked out of the nursing home while you're trying to sell the house. But again, power of attorney comes in real handy to help you sell the house if you're sitting in a nursing home. The other thing that's a mistake is that public aid pays for everything. Not really, but the people I have known in my life that had like an inheritance and it all got spent and they spent their own money and then they're on public aid, I don't see them suffering much. The hard part was used to that they didn't have enough money to have a telephone in their room at the nursing home. That was really hard on a lot of people. But I think nowadays my own experience with my family is that the phones are basically included in the price of staying there. So it doesn't seem to be a problem anymore. I personally have never seen a difference between the care that you receive when you're on Medicaid and the care you receive when you're private pay. I've never seen the difference. What I have seen is the difference in the decorations within a certain room. And sometimes it's not so dependent on whether you're public aid or private pay. It's whether you have family members willing to come in and decorate it for you and bring you in pretty pictures and things you like and whatever. So, but I'm not as afraid of ever going on Medicaid as some people, because I just haven't seen that much difference in the care or the rooms or anything like that. But public aid is for people who have no other way to pay on their own. And you have to disclose all your assets and all your income. This means if you're married, it's your income and assets and your spouse's income and assets. Now, a lot of my clients are in second marriages later in life, and they have prenuptial agreements that say, what's yours is yours, what's mine is mine, and we're not going to be responsible for paying each other's bills. Well, that's fine and dandy while you're married and if you get divorced, but it does nothing for public aid, because if you are married, you are expected to pay your spouse's care if your spouse doesn't have the money to pay their own. And so to get my spouse on public aid, we both have to disclose our income and assets. And then if he goes in the nursing home, which all my examples, he's the one going in the nursing home. I'm the what's called the community spouse. We report all of our income and all of our assets. I'm allowed the house, a car up to a certain value, and that changes a little bit from year to year. And it's not much. It's like a $3,000 or $4,000 car. You could probably get by with one that's worth a little more. I don't know that they enforce that. We're allowed 2 prepaid burial plans up to whatever the limit is at that time. My husband is allowed to have $2,000 in an account in his name, but not 1 penny more. And I'm allowed to have $109,000 of any assets I want, plus the house and the car and the household contents. So that's it. But the rule is I am allowed enough income and assets to remain in our home. But the state of Illinois still reserves the right to put a lien on our house, so that if I die before him and the house is sold, they get paid back. Or if he dies and I'm still living in the house, then when I later die, they've still got that lien on the house. So they will get paid back if the assets are there. Remember also that if there's a disabled adult child, if we had a child with disabilities that had lived with us, then that child would count like a spouse would to be able to remain in the home and get some assistance. In addition to the assets that I get to keep, what they call the non-countable or exempt assets, I also get so much of our income combined from, he has a pension, he has Social Security, and I'm going to have Social Security. I get the first $2,750 of our income. And again, that's to allow me to stay in our home. I don't know that I could do that in the home we're in now, but I could downsize and probably find a place where I could survive on that kind of income level. I'd have to stop shopping on Amazon, I think. But that's the basics of public aid for spouses. There is a brochure that's much more detailed that is available online. And in my outline there, on page 3, I gave you the link. It's a really, really long one. I just went to the Illinois Department of Public Health, or excuse, trying to remember what it is, but a much shorter website. And then I was able to get a link to it, but I had to dig pretty hard to find their material on spousal protection. And they refer to that as spousal impoverishment rules, trying to prevent the community spouse from living in poverty, because all the money is going to support Kirk in the nursing home. But instead now they carve out for the community spouse, and anything left over then goes to pay his care, and the state of Illinois pays any shortfall. Don't expect you to remember that, and it's in the outline. So here's the deal. Why not gift all your stuff to your kids now, and you can keep your pension and your income and then protect it that way? That is one plan, and a lot of people would like to do that because they really care about how much their kids are going to inherit. But one thing I tell my clients is I have a problem with you gifting assets to your family members or anybody else, because that is not in your best interest. If we're planning for you, and if you're planning for your parents, it's not, I would say it's pretty rare that it's in your parents' best interest to gift their assets away so that they qualify for public aid earlier. 2 reasons. Nobody knows how long they're going to live. And the state of Illinois currently has a 5-year look back period. So if my parents, this is frequently what people do, they will gift their house to their children, trying to protect one asset from public aid. And then if one or both of them go in the nursing home and they don't have a way to pay, the state of Illinois is going to look at it and say, well, did you have to report anything you gave away for less than fair market value. You can sell things, but if you didn't sell it for fair market value, you have to report that as well. Remember the days when people used to sell their house for $1? Doesn't work. And so you were considered as still having that asset that you gave away. And so there are very few exceptions. I don't even know if any of them work in the last 20 years. They did it early in my career, but so be very cautious about using gifting. The value of the gift itself, it may delay when public aid starts paying. And for instance, let's say that I gave a $10,000 car to my daughter and I report that to public aid. It's been less than 5 years since I made the gift. They'll look at the date of the gift and the value of the car and the average cost of a nursing home per month. And they'll take the value of the gift I made divided by the average cost, and I will be disqualified from public aid for that many months. So a $10,000 car, I'd probably only be disqualified for 2 months because I think it's at least $5,000 a month for nursing home care. So it's not terribly onerous, but the thing that scares me is this idea that the law is going to change. I have seen a draft of a change that's going to go to a lifetime look back period. What gifts did you make? And did you make those gifts just so that you would qualify for public assistance earlier? I don't think they'll ever pass that because it's been on the books for, let's see, 15 years now. It's been in writing 15 years. They can't do it. It's not practical to do that because that technically every birthday gift, every Christmas gift, terrible. So just know it's out there. Be aware that changes are going to happen. And gifting is kind of scary because the best thing for my clients is to hang on to all of their assets and use them as they need them. And if they have a cash flow problem because they're staying at home and they're paying some caregivers, we have some tools available that we can help them sell assets to their children and get monthly payments back that help them meet their cash flow needs for their caregivers without getting in trouble with public aid, because the child's actually paying fair market value, but just paying it off monthly. Let's see, making good time here. Again, just remember, and in the outline on page 3, I give you a list of the non-countable assets, the things that the community spouse gets to keep and try to survive. And I've actually got the number for the amount of income that I get to keep if I'm the community spouse, and the amount of any asset I get to keep. I get the house, the car, the burial plans, plus I get the $109,000. What I want you to be aware of is that they haven't changed that number for over 7 years. I didn't go back. I went back to 2014. I didn't go back any further to see when the last increase was. But I mean, it's better than nothing. I had a family where the husband went in the nursing home and they didn't have much, but she had 10 acres of farmland. And what happened was she got to keep that because it was under $109,000. She had the house, the car, and 10 acres. And it was psychologically was huge. So I was glad that that one had a happy result. Each family situation is unique. There is no one plan that fits. Sometimes gifting or selling for less than fair market value might make sense. I do very little of it. There are also trusts called Medicaid qualifying trusts. In 36 years, I have never done one. I've hardly even been asked to do it. I don't know how long they're going to be permitted. They are terribly disfavored when the Department of Public Aid, they review all trusts. Even if your mother left a trust for you, they'll want to read a copy of it to make sure it's not a countable asset. We do have, I draft a lot of trusts where grandparents set up a benefit for their grandchild who may be disabled, and we can leave assets to that child in a special needs trust, and that is by special statute a non-countable asset, as long as we have what I call certain magic language in there. If you want to know more about that, let me know. But I'm telling you, this is not fun stuff to talk about, is it? And don't wait too long to get started on planning if you're planning for your parents or other older family members. And don't forget to make that asset list of your own assets. If I were to die or become disabled, Shannon, you'd have to come up here and help my husband because he just lets me take care of everything. I've got a drawer with nothing but our asset information in it because I know how hard it is when you have nothing to start with, nothing. And like I said, we'll be glad to give you a very short form to help you start making a list. But the passwords, login and passwords are becoming really problematic because a lot of the big software companies are not allowing us access, even if we have a power of attorney. So if you've got that login and password, you can just get into it. You know, my dad was very computer savvy, And I admit, I go to his Social Security site, and up until he died, I would log in as him because I knew how to log in. But get started on a plan for yourself or whatever family members you're happy working with. Kind of think about who your advisors are, learn all you can. Don't wait necessarily for a crisis. And the other thing is, get a checkup on your estate plan, because with the community spouse rules, let's talk about the house in particular. If Kirk goes in a nursing home and I'm trying to qualify as the community spouse, I have to get his name off of the house and into my name alone. Power of attorney works well for this, but we have to have specific language to allow gifting, because I'm his agent and he's making a gift of his half of the house to me. So it might be worth paying an attorney to make sure you get your special language in there to allow that to happen. I don't know that Kirk would sign the house over to me while he's well. He'd probably have to be pretty disabled to do that. But the problem is, if we do that so that I qualify, and then what if I die first? My will says I leave everything to my beloved husband. If he's in the nursing home on public aid, it means that my executor, probably my sister, my brother, sell the house. He gets the money, he goes off of public aid, and I'm okay with that. But I could have had a plan that said, I'll leave my house to my brother and sister, and they know what to do with it. Buy him a big screen TV, a lift chair, things public aid doesn't pay for. But if you have children, sometimes you want to leave certain things to your children rather than leaving everything to your spouse. So think about the fact that we never know who's going to go first. And I had my very first clients when I opened up my own private law practice were from Effingham. And I remembered when they came in, the wife had leukemia. And so they wanted me to help them transfer all the assets to the husband. And then he was going to leave everything, to the children. And I said, I can't do that. And they said, why not? I said, because my law professor in estate planning said, never, never, never assume you know who's going to die first. So what happened, as you know, without hearing the end of the story, is he died suddenly and she lived a long time after. And because we split the assets 50-50, we had estate tax planning in there. They thought I was the most brilliant attorney. And all it was is it'd only been 2 years since I was in law school. I can remember my instructions back then. So get help when you need it. The hard part is knowing when that is, have a plan in place. And I'd like to open it up to questions if anybody has anything they'd like to ask me.
I'd like to ask you what estate planning records, you talked about the power of attorneys. Now you said in one of our other meetings that over the age of 18, you need a power of attorney.
Yes. Again, I tell stories because I think that helps people remember why it's important. I had clients call me one time and it was kind of late, like 6 o'clock on a Friday night, but of course I was there working. And the mom was crying because their 18-year-old daughter had left for college in Chicago the month before, and she was in the hospital. And they would not release information to her because she was over 18 and she hadn't signed a power of attorney, so they wouldn't release any information to anybody. And so that taught me a lesson that when your kids leave for college, when they leave for the military, if you have a single child that's moving away from home, I would try to get them to sign a power of attorney for healthcare and for property. The military does a good job of making sure that their soldiers do this, but colleges, I don't know. And if you think about it, it doesn't happen very often, but it is a wonderful tool. And my sister, one of her 3 children, had a burn as a little 3-year-old and had a little bit of money that they got from an insurance company. And my sister never told her about it. So when she left for college, we made sure that Rachel signed a power of attorney, my sister, and Rachel's now about 35 years old and still those statements are going to my sister. She doesn't want her to know about the money, but it is important because it doesn't have to be a chronic or an age-related illness, sometimes the sudden accidents. And I've had way too many clients in 36 years where a child was in an automobile accident, was seriously injured, and there were no powers of attorney to enable them to pay bills or go get his final paycheck or, sell his house, all the stuff. And so we ended up in guardianship court. My minimum fee for guardianship is about $3,000. And that's a lot of money for a family to pay when a power of attorney is almost free. if you come to my office and we do anything for you, we just throw in the powers of attorney. It's like we don't charge extra for them. And they used to tease me that if someone came in to ask for directions to Burger King, because we're across the street, I wouldn't let them leave until they signed powers of attorney. So, probably very important. And I blame the attorneys, because people come in and ask them for a will, and that's what they do. And they should say, you need powers of attorney, and don't let them leave until they sign them. Other questions?
I have a
Janet.
question.
Yes,
Oh,
sir.
go ahead.
Go ahead.
I have a question. This is Dave B. Me and my brother are caregiving for my father, who lives by himself for about the last 6 years after my mom passed away. He does have beginning stages of dementia. He still lives by himself and is able to care for himself for now. We have seen him progress, decline, I should say. My question is, here's the basis of my question. Several years ago, I'll just call it someone that lives in proximity of his home, showed a great interest in purchasing his house and his farm. They literally wanted to live in a different county, which is across the street. And so therefore, they approached my mom and dad. My mom put a stop to it pretty quickly, said, no, we're not interested in all that. Since my mom has been gone, this person has taken a great interest in coming over and kind of, walking in the house and taking care of dad. And my dad really likes, I'll just be honest with you, he likes the attention. Okay. Who wouldn't, right? He lives by himself. He's 80 years old, or real close to it, 79. My brother and I's main concern, obviously, is my dad's health and taking care of him, but also protecting him.
That's right.
Okay. And what steps, I work at a bank too, by the way. So I've had a lot of people give me free advice of, you need to look at guardianship. You need to look at this. Well, I've known enough about guardianship, which is very little, to know that is he probably wouldn't get it, because he still lives by himself. I am his power of attorney, and that's, you have more experience than I do. I'll finish the question with this. What advice, or where would you point me in the direction to achieve what I'm trying to achieve, which is to protect him and his assets?
I wish I had an answer, and you, and
So
all
do
I
I.
can tell you is, the best thing I can tell you is show up at different times a day. Vary
We've
your
put camera
schedule when
surveillance
you
cameras
drop
up.
into the scene.
We put surveillance
There you
cameras
go.
up,
And
we have caught the person there, and they get real surprised when you talk through them through the camera. And say, hey, we're here, we're watching, and all this. Power of attorney probably wouldn't cover if they tried to get him to do a quick claim deed or something like that on the property. I'm guessing.
You have some protection through the courts, but it is through the courts, and I always like prevention. So you are actually doing a very good job, whether you know it or not. The hardest thing in the world is that your dad is in that arena between fully competent and totally incompetent. And
Exactly.
all I can tell you is that you can get a limited power of attorney or limited guardianship. It doesn't have to be a full-blown guardianship if you really think there's a chance, because it's like with my dad, we could reason with him, but he wouldn't remember. And so one of the other things you might do is I don't know if your father has an attorney that he trusts, but sometimes if you clue in a longtime attorney that isn't also a friend of the person across the road, sometimes
he does have a long-term attorney. You know him well. You work with him, I got a feeling.
The guy that taught me everything. So one of the things that I would say is, hey, Dad, would you consider a land trust, putting your house and farm into a land trust? And I'll tell you why. He would see, if he would be willing to do this, with the attorney looking out over your shoulders, set up a land trust to own the real estate. And then you can be co-trustees with him. Say, no, Dad, we're going to keep you in charge, and you're trustee and I'm just going to be your co-trustee. And that means that he can't sell it without your signature.
Okay.
I mean, there's
We-
less, he could actually add your names to the deed now. He could just say, hey, would you deed this to us now and reserve a life estate? But there are some tax ramifications to that.
Right.
But the trust,
Which,
a simple little 3-page land trust agreement. And if your bank has trust powers, they probably have a 3-page, okay. Find a
we
bank
don't.
that has,
I know you do, or your former, or wherever. I know they do. So.
and I stole all, I mean, I copied all their forms. I have them in my
Okay.
file. So, but I would contemplate something comfortable for him, like a land trust, just to protect the real estate. And then
Okay.
I don't know that you thinking his other financial assets are at risk. It's harder to protect bank and brokerage accounts. But I will tell you, there are some pretty fierce brokers out there. We stopped one again at Effingham County, where a neighbor had written to a broker out of state and said, we need a change of beneficiary form. And the broker said, not sending it to you. They ended up the people that were trying to get the change made sued him, and he won. And then when the guy died, they all went to court over it, but they weren't having it because we had a guardianship pending for him that they didn't know about. So he already had disability. And we started all of this because of the mandatory reporting. There was a nurse at the hospital in Effingham that reported it to Adult Protective Services. That's how I got involved. They went out of county. And thank heavens for people like her that care enough to say, yeah, somebody's bringing this guy a bunch of documents to sign for his Cadillac, his house, his brokerage account. And it was a very interesting case.
Fortunately, I am on. I'm his financial for health and financial power of
Okay.
attorney, and he works with the advisor that works at my bank, and
Okay.
which I do also. So I'm on that with my father, at my brother's blessing. Matter of fact, my brother's on there too,
Okay.
and it's just my brother and I, the only kids we have or siblings I have.
Well,
And
good for
so
you.
that's somewhat. I don't want to say it's 100% ironclad protected, but we know what's going on there, I guess,
Yes.
is what I'm
Yes.
saying.
When
I'm
I
more
worked at
worried. I'm worried about the unknown when I'm at work and somebody stops by and my dad, just
that's right.
don't remember to call me first. So,
When I worked at the bank, our drive-up facility in Mattoon had a gal that got an award because there was an older lady sitting between two people in a ratty pickup truck, and she wanted to withdraw $8,000 because they were going to roof her house. And I don't know how the teller did, but she wouldn't do it. She just wasn't going to do it. And it turned out that the people got arrested, but they'd bilked a lot of other people in town by that time. So, other questions?
thank you.
Thank you. Keep me posted how you're doing.
I will.
Janet, I had a question.
Yes, ma'am.
If you have farm ground in a land trust, is the nursing home situation, are they able to get that farm ground if you're in long-term nursing home care, if it's already in a land trust?
They could still put a lien on it.
They could.
Yeah.
If the farm ground gets put in a corporation, is it then exempt, or do they put a lien against the corporation as well?
I don't know that they have a way to put a lien against stock, especially of a closely held corporation, but they actually have a pretty high priority claim at death against assets.
Okay.
But putting it in a corporation and getting back shares, you still have an asset and it's still worth whatever the ground's worth.
Okay.
Some of you are pretty quiet out there. Hard to say. One of the things I'll remind you too is that part of my job, I get to evaluate people's competency. Do I have special training for this? No. And it really bugs some people in the social work medical field because I speak to groups of I train social workers on occasion, and they get really upset. They've gotten really upset because I say, I get to decide if he's competent enough to sign a trust agreement, to sign a deed. I get to decide if another client's competent enough to sign a power of attorney. And the rule for us is, if I believe They know and understand what they're signing at the time of signing. I don't care about 10 minutes later. And there are instances where I actually refuse. Clients will say, oh yeah, mom's doing really well, you know, and like I said, I go to nursing homes, I go to hospitals, I go pure, I don't care. People will pay me to go because they didn't do planning in a timely fashion. And I'll walk away and say, I'm really sorry, you know, it won't happen. And in fact, that case down in Effingham in the hospital, there was an attorney that went to the hospital. He walked away and said, I'm not having him sign
And
this.
seal
It's not
carry.
competent enough. So,
Class.
other questions? So that's the key, is get this stuff done while they're competent enough to help you. And the most important thing, if you've got limited ability, just remember, they don't have to be able to sign their name. They just have to be able to make a mark with a pen. And they don't even have to be able to do that. I've had several, whether it's will, power of attorney, trust, signed at someone's direction. We had a young man who had a brain injury. He was still competent, but he was paralyzed from the neck down. So he instructed my secretary to sign his name to will, powers of attorney, everything. And so they don't have to be able to physically sign. And a lot of my clients that have had strokes know what they're signing, but they can't sign their name. And I don't care what kind of mark they make, works for me, as long as you can put a pen in their hand or direct someone else to sign for them. So don't let that be a roadblock for you as you try and get things done.
And you stated at the beginning of the program that you would give the people watching a half hour of your time.
Yes.
And
yes.
how long would it take to do powers of attorney for people? And
It'd take about 20 minutes. Very quick.
so that's something, you know, everybody can keep in mind.
Yes.
It doesn't take long, especially if you know who you want
That's right.
to that place.
And I can tell the few of you that let me see your faces, you're not very old. So you're worrying about somebody that's older, but please get yours signed, because it could be the situation I was in where I had to buy a car or I had to get narcotics. Now, the rest of that story is the third day when I went to get the narcotics, they refused. I was profiled as a drug abuser. I don't know what happened exactly. I know people were backing away, but I also know I walked out with those narcotics on day 3, but I must have convinced them I was sane. I'm hoping that's what it was. But really, most of the time, people in your situation just have some quick questions, and you don't always want to discuss it in front of a group. So get some help. And there are attorneys out there that do what I do and have done it a long time and have really good advice for you. So I appreciate you all being with us this evening.
Did you put your phone number on that?
Oh, you know, I actually noticed that I did that last time and I forgot to add it. Can I send it in the
Yeah, we could
chat
just,
right quick?
yeah,
Okay.
send it in the chat and then people can jot it down.
And when you call my office, if I'm not there, just say, I attended a seminar and she said I could talk to her. 217-234-7123. Check my typing. Okay, there we go. Thank you, everyone. I really like to feel like I'm helping you. So thanks for that.
You're welcome. And I know my sister and her husband came to see you and they were very impressed and,
Good,
and
thank you. Thank you.
they got it done in just a short amount of time. So they were very pleased with.
You know, if you want powers of attorney, when you call, tell them who you want to name. Have them typed when you walk in the door.
Yeah, you can do
So
that.
whatever we can do, let's get her done. And please promise to tell 10 people. Okay. Now I'm not going to do theirs for free, but you can help them after you see how we do yours.
I know several people on here, and tell your kids to get their powers of attorney done.
Absolutely.
Powers
Absolutely.
of attorney done. So,
Okay.
because that was one thing that really stuck with me with all your presentations. You need a power of attorney after the age of 18. It's like, oh, okay. Yeah. But yeah, I can see why you would need that. Any other questions that anyone has? You know, I think, did you put your email address on there?
Oh, I'll do that too.
Yeah. And then you know, you can email Janet. Or if you need her address or something, you can email or call me. I've got all that information too.
He knows where I live.
I know where you live. Yes, I know where you work.
And if you do come to the office, beware, we do have an office dog.
Okay. Okay, any other questions? If not, Janet, thank you so much.
Thank you
Appreciate
all.
Another
I
good,
wish y'all well.
yes, thank you.
Bye-bye.
Okay.
Thank you,
Janet.
Janet and Shannon.
Okay, thank you.
Thanks, Lois.
Have a good
Lisa.
night, everybody.
Okay.
Bye-bye.
Bye.